Hey guys, Darrell Brooks, despite his best efforts to only do things that benefit himself at any cost to anyone else, may in fact be the cause of something good, and that is a change in the bail law. This was brought to my attention by an astute commenter and channel watcher telling me about these bail amendments to the Constitution, so I took a look at it. Wisconsin has been kind of an outlier on bail for states around the country, in many ways good and bad. It doesn't have commercial bail, which many feel is a kind of racket. It also did not allow monetary bail to be set for any reason other than assuring future appearance in court proceedings. The state constitution in Article 1, Section 8 says monetary conditions of release may be imposed only upon a finding that there is a reasonable basis to believe it's necessary to assure appearance in court. And that's it, according to the Constitution. Or it was. Now, it does have a procedure for denying pretrial release without the use of bail, but it involves ultra-tight time frames and a complex process and is rarely used. Not a good system. Instead, of course, people generally expect bail to have an element of protection in it. And that's why they were so mad that Brooks' bail was so low. And you can bet judges considered that. But you might sense some trouble if there's nothing between cash bail only for appearance and safety considered only with a highly time-constrained, complex proceeding. What's in the middle? The case of Brooks being out on almost no bail despite his history of bail jumping and violence, it spurred lawmakers into action. Again, he's by no means the only violent person to reoffend while out waiting for current charges to make it to trial, but he was definitely the worst. Now, to amend the Constitution in Wisconsin, the state government must agree by majority in both houses on an amendment for 2 years, and then it goes to a statewide vote. And that has happened. Voters approved the two amendments proposed, roughly 67% support, which is pretty solid. The First Amendment deals with the ability to place conditions on release considering public safety for when somebody is released. And the second allows the judge to decide bail while considering the totality of the circumstances, now including previous violent crime convictions, probability of failure to appear, the need to protect the community, prevent witness intimidation, and potential affirmative defenses. Now, this kind of expanded universe of things a judge can consider, of course, may result in bail preventing an ultra-violent person the chance to do more damage while awaiting on trial. Denying a violent scumbag the chance to hurt innocent people is an obvious upside. Well, there are potential downsides. Again, you're pretrial detaining somebody who's supposed to be considered presumed innocent. Critics say, hey, money shouldn't be the tool to use to keep risky people in jail. And what's money got to do with risk? And this affects poor people more. It has race effects. It can also impact people, as I said, are presumed innocent and may actually be innocent. And they're sitting in jail for something they didn't do because they have this high bail. So let's go through this some. Now that the law is changing and judges will be able to expressly consider public safety and other danger factors in setting bail, critics say, hey, if it's risk you're worried about, then bail shouldn't be the issue or the answer. If the person is dangerous, keep them in. If not, let them out. Money and whether somebody can post bail or not doesn't deal with the danger of the person. And I think that makes sense, but consider this. If a person is rich, the judge can set a much higher bail. Problem solved if that's done. And is the solution to the theoretical secret rich murderer getting bail simply not using bail as a tool at all for public safety? That doesn't seem right. But I do agree with the criticism that money shouldn't be the determiner when public safety is the issue. It isn't for the criminal conviction when you finally do go to trial. But hey, get busy proposing your own changes to the system then that actually would accomplish that, this risk-based assessment. And you likely would have broad support. Where was that constitutional amendment? So because of that, I think some of the people citing this, they don't do that. They don't propose this other solution because they really don't want more pretrial detention because it affects this class, poor people, or this race or whatever concerns they have. They don't want more pretrial detention, so they're just using this as a criticism here. But if it is a genuine concern, and I'm sure it is for some people, either advocate for high bail for rich, violent people. I'm for that, which, by the way, this law certainly allows, or come up with your own better system where it's a risk-based analysis like some other states have. Other states have working systems that deny bail under certain circumstances for certain type charges without regard to money. Look at the Clinty case or the Adelson case as examples. I am of the view that you use bail for the assurance of appearance, but for safety, it shouldn't be money, but rather risk. And I don't care what color or creed you are in that. But if bail is the tool being offered up to protect public safety, as it is here, then make the best of it. The people worried here about racial effects do not seem concerned that the victims of these violent people are, despite what the media pitches, typically the same race. The racial component is only cited when discussing the alleged offender and not when discussing the victims. To me, what matters is due process and designing a system that achieves the most accurate outcomes. If there's bias in the system, address it. Don't ignore violent criminals, though, in the name of race. Come on. Now, if the concern is that the use of higher bail will simply become more common without due regard to risk, and so innocent people may more frequently lose their freedom, I get it. It doesn't show much faith in the judges being elected there, but I get it. The solution is to monitor the outcome of the cases and see if the tool is being abused, kind of like it got monitored and was found sorely lacking on Brooks and others who were let out to wreak havoc on the public, and now it's being changed as a result. Fix it. Don't ignore it. I agree with anybody who says there should be a bias against any bail, period, unless the person is demonstrated to be a flight risk or if the law allows an actual danger to others. But I disagree with anybody who says because the tools being provided aren't perfect, we just shouldn't deal with public safety. Just don't fix it. Just leave it alone. It might have some bad effects. There was a lot to like about Wisconsin's approach to bail. And, for low-level offenders, it still probably needed attention to reduce or eliminate unnecessary bail. That's always historically been an issue. But it was a poor system, though, for ultra-dangerous offenders, and changes make sense. It didn't have the middle ground to give the judges the flexibility they should have and the accountability that they ought to have. These amendments let judges consider the dangerousness of defendants when setting bail. And the corollary is it also means the judges are responsible to the people who elect them to do that. And this makes sense. It's not perfect, nothing is, but this tool, if used well, will prevent violent criminals from victimizing innocent people. If it gets abused, modify or improve it, but something needed to be done and it has been. Thanks, Darrell. You were so awful, you actually resulted in the system doing something good to protect the community. Well, thanks for bringing this topic up to my attention. That's it. Thanks, bye.